Hello and welcome to this talk on bringing a claim for judicial review. I'm going to talk about listing and a few other matters in this talk. My name's Declan O'Dempsey. I'm a barrister at Cloisters Chambers. The Administrative Courts Guide sets out a lot of detail that you may need to look at on the policies of the courts in relation to listing. And they recommend that you go to the court's website to have a look at the current listing policy. If you're in Wales or bringing a claim in Wales, you'll need to have a look for the supplementary listing policy at Cardiff. Whatever policy is adopted, you need to bear in mind that the court regards its policy as flexible. However, there are some general rules. Permission hearings, for example, will usually be fixed for a date without consulting the parties, and they'll be fixed quite a way in advance. Usually several weeks' notice of the hearing will be given. In relation to the merits hearing, the substantive hearing, the Administrative Court Office will usually consult with the legal representatives. So if there's a barrister involved in the case, then they will consult with the barrister's clerk to attempt to agree a suitable date for the hearing. And there are different policies. In London, the court office will telephone or email the barrister's clerk or the solicitors to arrange an appointment in order to fix a date for the hearing. 5 working days notice is given for this appointment, and if the parties are unable to agree a date that's also acceptable to the court, then the court office will list the case for the first available date which is convenient for the court. Failure to attend the appointment means that the case is listed without further consultation. So that's the policy in London. Elsewhere, the court office will email or telephone counsel's clerks, and they'll do that in relation to all the parties. And they'll request the dates of availability for any barrister who is, as they say, on the court record. Now, this means that the court's been informed that the barrister is acting in the case. Unless availability is provided over the telephone at the time of the initial contact, the clerk will be informed that they must provide availability within 48 hours. If they don't do that, then they're told that the court office will list the case for the first available hearing, which is convenient to the court. Similarly, if the parties are unable to agree a date, which is also acceptable to the court, then the court will list the matter for the first available date, which is convenient for the court. In relation to interim hearings, which I spoke about in a previous talk, these cases are listed in much the same way. If an interim relief hearing is required urgently, the hearing can be listed at short notice with little or no consultation as to the availability of the parties, as you might expect. However, the application will usually be fixed on the basis that it'll take no longer than 30 minutes to hear, unless a different time estimate's required by a judge or a master or the Administrative Court Office lawyer. If you think that your application will require a longer hearing, then you must write to the court office suggesting the time estimate that you have. You've got to do that as soon as possible, and you must provide your reasons as to why you think it's going to take longer. The court office says, in relation to litigants in person, that it's unable routinely to take into account their availability. It says the same in relation to solicitors who are instructing counsel. Now, if you're a litigant in person, and if there are dates when you're not able to come to court, and if you've got good reason for not being able to attend the court, you can inform the court office. You must do so in writing. You must do so in advance of any attempt to fix a hearing. The court office may be able to take that information into account when listing, and generally speaking, they will try to do that. In relation to hearings on the merits, the substantive hearing, what happens is that the judge who granted permission, or the administrative court office, will have allocated a hearing time estimate at that stage, so when permission is granted or shortly after. If you think that the merits hearing is going to require longer, then you must confirm that to the court office. You should give your suggested time estimate. This must all be done in writing, and you must give reasons for the time estimate that you're giving. Once the case is listed for hearing, everyone gets sent a listing notice which confirms the date, location and time estimate for the hearing. However, the start time is not given in the listing notice. Generally speaking, merits hearings will start at 10:30. That can be changed up until 2 o'clock on the day before the hearing. So the best thing you can do is to check the hearing time on the day before the listed hearing. You can do this by telephoning the court office, or you can check the hearing time online at the website. But remember that it can be changed up until 2 o'clock in the afternoon. You will have heard reference to a divisional court. Now, a divisional court means that 2 or more judges of the administrative court sit together. The rules for listing these sorts of cases are the same, and you should note that the divisional court can be convened for any case in the High Court. If you've been allocated to a divisional court, there are some differences to the listing arrangements, particularly if the case is urgent. And because they're trying to coordinate 2 judges to sit on the case, or maybe more judges to sit on the case, the court office can't offer as many suitable available dates, and generally they won't take into account the availability of each party's legal representative, so the barrister, when they're listing the case. In other words, they will list it so as to ensure that the 2 or 3 or more judges who need to sit on the case can sit on the case.